One of the biggest fears riders have after a crash is this: I was lane splitting, or I wasn't wearing a helmet. Do I still have a case? And in California, the short answer is often yes. So in this video, I want to walk you through the right framework, not panic, not assumption, not insurance company logic. Let's start with lane splitting. California DMV guidelines states that lane splitting is legal in California. The DMV describes it as a motorcyclist riding between lanes of stopped or slower moving traffic, or moving between lanes to the front of traffic stopped at a light. California Driver Materials also tells motorists it is legal to share lanes with motorcycles. That point alone matters because a lot of drivers and even some adjusters still react as if the rider must have done something inherently illegal just by being between lanes. Lane splitting is not an automatic strike against the rider. It does not automatically eliminate the claim, and it does not automatically mean the motorcyclist caused the collision. The legal question is not simply, was the rider lane splitting? The question is, did the rider's conduct contribute to causing the crash, and if so, to what extent? That is a very different question, because in California, more than one party can share fault. Now let's talk about the helmets. California requires riders and passengers to wear US DOT compliant motorcycle safety helmet. That is the rule. But when a rider was not wearing a helmet, people often make the next leap too fast. They assume that means no claim, no recovery, no case. That is usually too simplistic. The better question is, what difference did that fact make in the specific case? Because not wearing a helmet does not automatically cause a driver to turn left in front of a motorcycle. Because there's a difference between who caused the crash and what may have affected the severity of the injury. These are not the same legal questions. So again, the presence of a bad fact does not necessarily end the claim. It changes the analysis. It does not automatically eliminate it. This is the part riders need to understand most clearly. In cases like these, the law is usually not operating through simple yes or no shortcuts. It's operating through a more nuanced framework. What caused the collision? What contributed to the collision? What made the injuries worse? What can actually be proven with the evidence? California comparative fault principles allow responsibility to be divided rather than treated as all or nothing. The rider's job is to understand whether the fact truly changes liability, truly changes damages, or simply being used as leverage. Insurance companies love facts that sound decisive even when they're not. Lane splitting, no helmet, rider error, unsafe choice. These phrases are powerful because they trigger assumption facts. And once the assumption takes hold, adjusters may start treating the case as discounted before a proper investigation is complete. That is why riders must be careful. In these cases, language matters, so be disciplined. This is where the case gets real. If lane splitting is part of the collision, the important questions often include traffic speed, lane positions, visibility, whether a driver changed lanes subtly, whether signals were used, whether the rider was moving in a controlled way, what independent witnesses saw, what vehicle damage and scene evidence show. If a helmet use is part of the dispute, the important questions often include whether the disputed injuries are the type a helmet may have affected, the medical timeline, the severity and location of trauma, what doctors and records show, whether the defense is overreacting, and how broadly it frames the helmet issue. This is why these are not internet answer cases. They are evident cases. One of the worst mistakes riders make is emotionally surrendering too early. Because some of the strongest injury cases begin with the facts that appear difficult on the surface. What matters is whether the evidence shows negligence by the other side, whether the rider still suffered compensable harm, and whether the defense's argument is narrower than it first appears. If you were injured in a motorcycle accident in California and lane splitting or helmet use is part of the story, do not assume the case is over. Get the case evaluated correctly. Book your call with me today and let's talk through what happened, what may affect your case, and what the law and the facts may actually support. So if you take one thing from this video, let it be this. Lane splitting does not automatically destroy a claim. Not wearing a helmet does not automatically erase a claim, but both facts can affect how a case is argued, valued, and defended. Which means the right response is not panic. The right response is analysis. In the next video, we're going to go deeper into the liability side of this and answer the next major question. Who is actually at fault in a California motorcycle accident? Because that is where the legal story becomes even more specific.